Good afternoon, ladies and gentlemen. My name is Vasilis Staikouras. I'm a senior financial editor at Open TV and mononews.gr. We're going to talk about corporate transformations in the context of this session, which will last 20 minutes. We have with us Mr. Dimitris Sirigos, Director in the Business Monitoring Services Department of SOL Krawe. How do you do? Good afternoon. Good afternoon. I'm fine. Thank you. So, corporate transformations. This is a topic that is of interest to Greece during the last few months, or we could say years. So, which is the law that governs corporate transformations, and which are the aspirations, and basically, what is the scope of the corporate transformations? The first part of Law 4601 of 2019 refers to corporate transformations. Allow me to show you a slide, please. Here you are. So, yes, you can see here the slide. So this law, the first part of this law, has 149 articles that are divided into 5 parts. The first part contains the initial provisions. The other 3 parts, that is 2, 3, and 4, include the provisions on the 3 main categories of transformations. And the 5th part pertains to the transitional and final provisions of the law. The scope of the law is anything pertaining to corporate transformations, that is from the start till the end of the corporate transformations and any consequences that may arise. The aspiration of the law, we would say, is to defend the rights of the minority of the shareholders slash partners of the corporate companies that take part in the transformation, and of course of the creditors, as well as an effort of a unified treatment of the transformations in total. What do I mean by that? I mean that regardless of the form that a company will choose, that is, regardless of the corporate transformation that a company will choose, the steps need to be identical. So we're going to have one single framework, common rules, to put it this way. Yes, correct. However, the law is very special. It requires attention so that the users, that is, the companies, will not be faced with surprises, which means that their transformation will not be completed. So the point is to use it as a lever of growth for the Greek economy. We need this growth. Greece has an investment gap of approximately 100 billion, something that has been observed by the European Commission as well. So which are the types of corporate transformations that pertain to this law in order for us to get the wider framework, Mr. Sirigos? I need to take a look at my notes. Yes, yes, of course. And the second slide here on your screen, this will allow you to understand better what we are talking about. So, the types of corporate transformations are 3: merger, reorganization, and demerger. When we're talking about merger, we basically mean the act through which the whole assets of certain companies that are taking part in the transformation is transferred to a new company or to an existing company. The companies that transfer their assets are dissolved without being liquidated. This is different to the existing framework that we all know, because liquidation was something very common as a concept, as a word. Now, when it comes to practice, things are different. Look, the rationale of transformation is based on avoiding liquidation. We need to opt for a new type and avoid liquidation, which is time-consuming and very costly. Merger is divided into 2 subcategories. If the company that will receive the assets of the merging companies is already existent, then we have the merger through absorption. We have merging companies absorbing a company. If the company that will receive the asset of the existing companies is newly established, then we have absorption through the establishment of a new company. The characteristics of the merger now are very specific. First of all, the companies that are taking part in the merger and give their assets are dissolved without being liquidated. And the shareholders or the partners, which depends on the form of the company and of the companies, take part in the capital of the absorbed or the new company that will receive the assets of the previous ones, which means that the right of the shareholders is not lost, it is only transferred with the new percentages to the new company, be it existent or not. Now, the second category is the demerger. In demergers, we have the company that is demerged and which is different to the previous case of the mergers because the assets are transferred to two or more companies. And here we have three subcategories. The first is the joint demerger. The second is partial demerger and spinning off. In the first part, we have all the assets of the demerging companies being transferred to the new companies, and this is where we again have the shareholders of this initial company taking part to the share capital of the new companies, of the benefited companies. In other words, the company is dissolved without being liquidated. But if we take a look at the two other cases, partial demerger and spinning off, then we will see that the initial company continues its activity, which means it chooses one or more sectors where it wants to demerge its activities. And these sectors in the plan of contract are clearly stated, and which of these sectors will end up in the benefited companies. The initial company is not dissolved, continues to operate, since there are other sectors where it continues to operate as normal. And there is the following distinction between the two subcategories. In the partial demerger, there is participation. The shareholders of the initial company in the capital of the new companies, whereas in the spinning off case, the company itself is taking part, which means that the merger or demerger are two forms of transformation. We would say that the existing companies basically change form. We have the process of the dissolution of the company that will choose to transfer all its assets to two or more companies or by one company that will absorb the assets. And in the case of merger, common demerger or partial demerger, we have the participation in the capital of new companies of the shareholders of the existing ones, of the initial ones. Whereas when we're talking about spinning off, participation in the capital of the new share is made by the company that decides to proceed to spinning off. So let's talk now about company reorganization. Limited liability companies. These companies can do that without dissolution and without liquidation, which means that we leave behind all the common difficulties and problems since the company is transformed from one corporate form to another with the same identity, however, which means that the tax registration number remains the same. Allow me to complete my answer. Now, which are the corporate transformations that allow which are the different form of companies that take part in the corporate transformations? Limited partnership, urban cooperatives, European companies, European cooperatives. The ones that are excluded are the one-person companies, the farm cooperatives, unions and foundations, and society, basis of a civil code. Yes, because their organization and their form is very different, and they are governed by different rules. So these are the forms of corporate transformations. Allow me to become a little more journalistic, since we want the cliches and the more simple things. What happens in the case of a corporate transformation when it comes to employees? Do they have rights? If we have a demerger, if we have the transfer of a whole company, if there is a change of the tax registration number, what happens then? Is there any protection of the employees in those cases? Yes, of course, there is protection of the employees, and this is mentioned in Article 12 of the law, in which there is reference to the protection of the employees' rights in case there is a change of employer. So you can see that the law has paid attention to that. The Greek legislation has harmonized to the union law, and moreover, when it comes to other laws that are referring to employees' rights being questioned, again, we can see that there is the necessary sensitivity that ensures the protection of the employees' rights in case there is a change of employer. Yes, because you said that in certain cases the shareholders get shares in the new company. So basically, they have some requirements. And of course, the employees have some demands and requirements vis-à-vis the shareholders. Is there a competent authority, a competent body for the settlement of disputes? Yes, of course, there is a competent body, which is clearly stated by the law, and it is the single member first instance court. But allow me to go back a little bit and talk about the steps that are included in a successful transformation. Yes, of course, this is the most important thing. So in order for a transformation to be successful, specific steps need to be made. 8 in total. First of all, there has to be the contract for the merger-demerger. Second, to publish this plan in the official gazette. Third, explanatory reports on the plan of merger-demerger. Fourth, examination of the contract plan for merger or demerger by independent experts. Fifth step is decision-making by the General Assembly or by the partners regarding the merger, demerger, or transformation. Next step, preparation of all necessary documents, and then reporting and publishing of the conclusions of the merger, demerger, or reorganization. Now, these 8 steps aim at simplifying the process. 2 of these steps may be skipped. The third, which is the drafting of a detailed explanatory report, and the fourth, examination of the plan for merger or demerger. These 2 can be skipped if there is in writing the consensus of the shareholders. In other words, if there is the agreement of the shareholders with regard to what is stated in the plan and in the explanatory note. And one last thing, the time period that is required or that is stated is at least 1 month, because the recording and the publication of the plan in YEMI needs to be uploaded 1 month before the decision made by the General Assembly. So if this is the case, then the transformation will be successful. Okay, these steps are not so simple as many other things in Greece. But one last question in the 3 minutes we have left, Mr. Sirigos. Lately, we have been hearing about mergers and about powerful corporate transformations. Can these be a lever of growth for the Greek economy? Because a lot in theory, very few in practice. Look, a transformation and a merger, if you like, is a corporate act. It is the decision of a businessman who will decide and proceed to action. If we approach it from an economic perspective, we have, of course, the development of economies of scale. We have more capital efficiency since there are going to be mergers of companies. So what is required is the following. If these transformations are encouraged, then certainly we will have better and more powerful schemes in the Greek economy, more flexible decision making, so that the needs and challenges can be met. Moreover, it has been heard that there is this new law that will provide bonus to those transformations. We hear that this law foresees a 30% discount on income tax for the coming 3 years, and on the basis of the law will actually acknowledge the cost of the acquisition, which is in itself an important incentive for serious companies who want to join forces. Okay, of course, here we have many ifs when it comes to this bill of law. Of course, we can talk about it later on with the next speaker, but the point is that this is something that the country needs, because you mentioned the joining of forces, which is absolutely necessary for the economy. And this is also true for the banks, isn't it true? For example, if we have a merger of companies, they can ask for a loan from a bank and have a more favorable position with regard to that. Yes, I believe that this is the bet of the near future. Thank you very much, Mr. Sirigos. I think that we have observed the time given to us. We had with us Mr. Sirigos, who is director in the Business Monitoring Services Department of SOL Krawi, and we can conclude this panel right now, and we will be back again very, very soon in order to talk about this transformation and mergers.